All right, well, I think we'll go ahead and get started. I'm Ben Kunkel, Director of Student Programs at the Ashbrook Center at Ashland University, and thank you for joining us today for our fourth spring webinar. We've got two technical assistants on hand today, Katie and Francis, who can help you if you're having any issues with the platform. If you right-click on their names and select chat, you can communicate with them. I'm sure they'll be happy to help you with any problems you're having. As we get started, feel free to submit questions for the professors using the Q&A section in WebEx, and they will try to answer all of them before we end today. The subject of today's program is Plessy versus Ferguson and Brown versus Board of Education, the beginning and end of segregation in America. Joining us to discuss these two Supreme Court cases are two Ashland University professors, Dr.Jeff Sikkenga, who in addition to being a professor is also the executive director of Ashbrook, and Dr. Burkett, who directs our undergraduate program, the Ashbrook Scholar Program. Gentlemen, you ready to go?
Sure. Happy to be here. Thanks. And it's always good to see you, Jeff. And I've been looking forward to this conversation all week. So, how should we proceed? Would you like to go first, or would you want me to go first?
Well, I think if you want to start us off, that would be perfectly fine, and I'll jump in. Happy to do it.
Yeah, sure. I mean, maybe we could just start with some general remarks on the Plessy case, and then work our way from that to Brown.
Sure.
So, okay. Well, before we get into the text of the opinions, of course, two very famous opinions in the Plessy case. One, the majority opinion, written by Justice Brown, and of course the famous dissent by Justice Harlan. So we can look at the arguments of both of those opinions in more detail. But before we do that, I was just going to make a few general observations about this case and what I find interesting about it. Of course, we know that it has the effect of legitimizing segregation based on the principle of separate but equal. But my first observation is I think it's important for us to remember that Plessy v. Ferguson, the decision of the court in this case, did not establish segregation, right? It did not officially begin racial segregation. Racial segregation had been going on for a number of years, obviously, before this. And segregation laws were initiated on the state level and had been, again, in place for decades, some even stretching back to before the Civil War, even in certain northern states. So what Plessy did, what the decision of the majority opinion of the court did in the Plessy v. Ferguson case is it established the legitimacy of those state laws so long as the segregation in place met the test of equal in terms of some sense of equal, right? Whether it meant equal availability, equal number, equal quality of facilities in the case of, separate railway cars, restaurants, public meeting places, restrooms, and those sorts of things. So what the Plessy case did was establish the test of equal. And as long as the segregation laws of the states met that test, then those segregation laws were justifiable under the Constitution, according to the decision of the court. My second general observation about this case is what I find really fascinating about this is the extent to which this was staged. I mean, if you want the Supreme Court to hear your case or hear a case on an issue that you find extremely important, there's got to be a violation of a law. And so to make sure that this case gets to the Supreme Court, somebody has to violate a law. And this was, in this case, this was extraordinarily well orchestrated in the sense that Homer Plessy intentionally violated the Louisiana Separate Railroad Car Act of 1890. Almost everybody involved in this knew beforehand that he was going to do this. Even the railroad company itself knew in advance that he was going to do this. And the railroad company didn't like the law because it actually cost them money to maintain separate facilities or separate cars for the white and black races. And so they were in on it. They even hired Plessy's supporters and lawyers even hired a detective to arrest him on on the spot. When Plessy sat in the whites only car, they hired a specific detective to arrest him just to make sure that he was arrested for violating this particular act and not arrested on the grounds of disturbing the peace or vagrancy or something else on those lines. They wanted to make sure that he was arrested specifically for violating this particular act in Louisiana. So this is a very well orchestrated violation of law, and it really an important early act of civil disobedience in a certain sense, right?
That's right. And I would just add to that, I think that's really important. Sometimes when we read in textbooks, they can only give us a very brief synopsis of what in fact happened. And the details, as you're suggesting, are really interesting in both these cases. But I think there's also some myths that have arisen around Plessy v. Ferguson and around Brown versus Board of Education. And one of those interesting details is that Homer Plessy was only, I think, 1/8 or 1/10, it's not quite clear, but African American. So, and again, so why have a person like that, who, as they say, could pass for white, why have a person like that be the one who the detective arrests? And the argument was, well, because he would be a sympathetic plaintiff in court, right? When you're already looking for court, you're always looking for who will judges and juries and appellate courts, who will they be inclined to look upon favorably, and to point out the absurdity of the law. That you're talking about a person who, to most eyes, who are untrained at least in these things, would not have looked like he would have been violating the law. So and it was an organized group of folks in New Orleans that he was a part of, who in fact hired one of the most prominent civil rights attorneys at the time so that they could stage the event, get arrested, and be ready to go with legal attacks on this kind of segregation. So as you say, Professor Burkett, it was a well-orchestrated campaign that was really not an isolated event, but part of a larger early civil rights movement push to attack these kind of laws. Because we're talking now, the law was passed in 1890, and let's not forget in our American history that Reconstruction has ended about 1876, 1877, when there's a lot of progress for African Americans during the Reconstruction times, including in places like Louisiana. So the progress is sort of attempting to be rolled back and is being rolled back by 1890. And so you have progress on equality and civil rights, then pushback, and then there's pushback against the pushback. And that's what really the events of Brown versus Board, of Plessy versus Ferguson, that's how they transpired. They're part of that larger movement and pushback against the rolling back of rights that had been won.
Yeah, that's a great point. As you know, after the Civil Rights Acts of the 1870s and the 14th Amendment, and the other Civil War amendments or civil rights amendments. So, but can I ask a question though? So you had mentioned when you were talking about the myths that have arisen, and you were clarifying some things. The reason they chose Plessy, again, yeah, he was considered to be what they used to call an octoroon, which is a politically incorrect term today, obviously, but somebody of 1/8, really 1/8 African descent, right? So do you think that, did they actually choose him because he would appear to be a sort of sympathetic person in appearance? They did actually choose him for that reason, or is that a myth? I was just unclear on that.
No, he was part of a larger civil rights group in New Orleans, right? Let's not forget again some of the racial dynamics in New Orleans at the time, right? Because New Orleans is a place that has a large what were called colored class of people, right? So not black, not white, but somewhere in between. And they were recognized as a kind of class in society, and he was part of that class. And they were really the ones who were agitating primarily for civil rights, because a lot of them were well educated, a lot of them were established in New Orleans society, and they were spearheading it because they had the means, they had the capacity, and they were used to a certain social position in society. So he, by virtue of being in that group that was agitating for civil rights not to be rolled back, he became part of the case.
I see. Oh, that's fascinating. Yeah, because I had heard the other point that you had made, or read about the other point, that he was, again, 1/8, and the other reason he was chosen was because, to point out the ridiculousness of the law. I mean, the question is, do we emphasize the fact that he's 1/8 black, or that he's 7/8 white, right? And so there was a kind of ridiculousness of the law component to his. And really in a way, pointing out the ridiculousness of what had come to be known as the one drop rule, right? Didn't matter whether you were 1/2 or 1/8 or 100th black, that made you, or African of descent, that made you black. And that meant that for all intents and purposes, somebody who looked from outward appearances to be entirely white, they would still have to legally sit in the car set aside for black. So yeah, good. That's interesting. That's really interesting. One other thing, by the way, one other interesting thing I find fascinating about this case is the personalities and the background, so to speak, of the justices themselves. I mean, we all know from our perspective today, this is regarded as one of the worst. I mean, generally speaking, people regard this is one of the worst Supreme Court decisions, up there with the Dred Scott case, right? From our modern perspective. And I'm hoping what we can do today, before we turn to Brown, is at least go through the arguments of Justice Brown, and try to do that from an understanding first from the circumstances of the time. So let's kind of go back to his point of view on things, or what's going on at the time, before we come back to our own time and pass judgment, if we will. Right. I'm a little bit on a soapbox here, but we know how easy it is for us from our modern perspective to look back and say, this is just wrong. And I do think it's wrong. Right. But there are social forces and historical forces and political things going on at the time that complicate this decision in that particular moment when it's made. But the backgrounds of these justices. So Brown is remembered for issuing or writing one of the most notorious Supreme Court opinions of all time, in justifying separate but equal. And Harlan is remembered as the great dissenter, in this case, calling for a colorblind constitution and opposing the doctrine of separate but equal. But I'm always fascinated by the fact that Justice Henry Billings Brown was from Michigan, never had anything to do with slaves, to my knowledge. I was educated at Yale, spent time in New England, and never really showed any signs of being, pro-segregationalist in his life. And in fact, in other decisions of his, he issued opinions that were quite sympathetic to the civil rights of other minority groups. But he is remembered as issuing this particular opinion. So it's just kind of strange that, but again, I forgot to mention he I think opposed most parts of the Chinese Exclusion Act, for example. He supported the idea that under the 14th Amendment, a child born of Chinese parents in the United States was a U.S. citizen, for example. So he's not remembered for those decisions primarily. He's remembered for this decision justifying separate but equal. And then on the other hand, you have John Marshall Harlan making the case that the Constitution is colorblind. He's raised in Kentucky in a slaveholding family. In fact, he had a half brother from his father who was born into slavery. He was a Whig like Henry Clay. He ended up fighting for the Union during the Civil War. But he was critical of abolitionism throughout the 1850s. He voted against Lincoln in 1860. He was a vocal opponent of the Emancipation Proclamation as on the grounds of executive overreach. He even was a vocal opponent of a lot of Reconstruction measures, including the Civil Rights Act of 1875. And yet here you have Justice Harlan writing a dissenting opinion against the doctrine of separate but equal. in this particular case. So I just find that fascinating that in some ways these are unlikely justices writing the opinions that they end up writing. So,
Yeah, that's for sure. And I think, two things come to my mind on that. One is it tells you that you can't always know or predict how a justice is going to vote on a case. When it comes to constitutional thinking, your background, where you're from, your race, your class, your gender, that doesn't always decide things. That these people have independent minds and they're approaching the Constitution and trying to understand what it means and trying to think it through. So you're right, from the point of view of backgrounds, these guys should be switched, but they're not. And I think the other interesting thing to my mind is you mentioned that Justice Harlan was critical of the 1875 Civil Rights Act because it was a number of those pieces of Reconstruction legislation. At the same time, a case that precedes this, which bears mentioning, is the civil rights cases of 1883, which were in fact about the Civil Rights Act of 1875. And in that act, one of the things Congress did was it said that places of public accommodation, so like hotels, opera houses, things like that were common at the time, places of public accommodation cannot bar people because of their race. So in other words, Congress passed a law forbidding segregation across the whole country under its power on Section 5 of the 14th Amendment, which says it has the power to enforce equal protection of the laws. And what was really interesting in that case, Justice Harlan was again the only dissenter.
That's amazing.
So he dissents that was in 1883, where even though he was critical of the law on policy grounds, he said on constitutional grounds, it's fine, right? So there's a big difference between thinking a policy is a bad idea or unfair or something and thinking that it's unconstitutional.
Yeah.
He thought it might not be a good idea, but it's perfectly constitutional. But he was the only person in that case who dissented. And what's really interesting is years later, not until 1964, when we're talking about the Civil Rights Act, the famous Civil Rights Act of 1964, are some of the arguments that he makes in the civil rights case in 1883, so 81 years later. Some of those arguments are brought back up again and adopted by some members of the court. So, it's really an interesting case of a guy who may have not agreed on the policy grounds, but took a principled constitutional stand. But those arguments are not picked up by people. He's a lonely dissenter for a long time on these issues.
Yeah, again, that's such a great point. In a time where we, not just our time, but some people have a tendency to think that it's impossible to step outside of your own personal views, right, and make impartial decisions. But I think what's interesting again about this, and Jeff, you did a great job of explaining this or articulating this. The opinions of these justices reflect a willingness and an ability to put their own personal views, whether they're policy views or even views on race, put those aside and make arguments from their understanding of constitutional principles. So I think that's a great lesson that we can take from both of these opinions, despite the notorious nature of Justice Brown's opinion. So again, I've read, in various places that Justice Brown, must have been a racist, and it's simply not true. There's no evidence to support that. And that Justice Harlan was a great civil rights crusader. He's kind of remembered as that in certain circles. And the fact is, he was kind of a lukewarm civil rights supporter. But when it comes to constitutional interpretation, this is a great thing I think we can take from both of these cases, is that they're putting aside their personal views and their policy preferences, and subordinating those to their understanding of constitutional principles. So that's great. So when of course Plessy is when he's initially arrested, he gets a trial in a Louisiana state court, and that is he loses that case, and then of course it finally does make it to the Supreme Court. His attorneys make a number of arguments, as we know, to which Brown and Harlan both reply or respond. And Jeff, please add to these if you like. But my understanding is there were basically two, maybe three main arguments of the attorneys. One has to do with the 13th Amendment, that is the railroad law of Louisiana, and enforcing separate railway cars for blacks and whites is a violation of the 13th Amendment. And the argument there is that that though it's not, the 13th Amendment did away with slavery, and though this is not actual slavery, it separate cars enforce or impose on blacks a kind of badge of inferiority, and therefore, or a badge of slavery, I think is the term that they use. That is, it reminds people of the historical connection of the black race with slavery. And so therefore, in a way, is a violation of the intent and purpose of the 13th Amendment. And I think connected to that, I believe his attorneys made the argument that this is therefore also a violation of property rights, in the sense that one's reputation is one's property, and to the extent that one's reputation is diminished by the fact that you're black, that's a violation of a property right. I think they made that argument as well. But the other argument, of course, they made was on the grounds of the 14th Amendment, which I know you know really well, and that was that this was a violation of equal rights, right, before the law, equal civil rights. Brown rejects all of those arguments. Does that, Jeff, does that sound like the sort of meat of the argument?
The phrase they used, that's right. So it was the arguments, they were rooted in the Civil War or the post-Civil War amendments, the 13th and 14th Amendments. Yeah, and the phrase I think they uses with the 13th Amendment was that this constituted a badge or incidence of slavery.
That's it. Yep.
Yeah.
Perfect. So Brown responds, if anybody happens to have the text of the opinion out, Brown replies pretty early on that he, in writing the opinion of the majority of the court, and this was a 7-justice majority, Harlan being the lone dissenter, and one justice, I believe, was home. I believe his daughter had died, so one justice was not participating in this case. But Brown very quickly rejects both arguments. It makes pretty short work of the 13th Amendment argument. Justice Brown writes that it does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude except as a punishment for crime, is too clear for argument. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as chattel, or at least the control of the labor and control of the labor and services of one man for the benefit of another, and the absence of a legal right to the disposal of his own person, property, and services. A statute which implies merely a legal distinction between the white and colored races, a distinction which is founded in the color of the two races and which must always exist so long as white men are distinguished from the other race by color, has no tendency to destroy the legal equality of the two races or reestablish a state of involuntary servitude. So indeed, we do not understand that the 13th Amendment is strenuously relied upon by the plaintiff in error in this connection. So, Jeff, by that last sentence, does that mean Brown is saying, we don't think you're really taking that argument too seriously, you're just kind of throwing that in there? Or does that mean that this is the weaker of the two arguments?
I think he wants to say, look, you can't be relying on this too seriously because it's not a very serious argument.
Yeah.
Right. That's the point he makes. It's beyond dispute. But I think it's worth noting there what Harlan says about that, because Harlan actually adopts and embraces the argument that Plessy's attorneys made, which is they say, look, what did the 13th Amendment do? It abolished slavery, right? I'm looking at it here, and it says, neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or in any place subject to their jurisdiction. So what does it mean that slavery shall not exist? And the argument that Plessy's attorney made was slavery isn't just the legal ownership of one person by another. Or it is that, but it's not just that. So what happens when you abolish slavery? So, right, Brown is saying, well, when you abolish slavery, all that means is you're getting rid of the legal ownership of one person by another who can take that other person's labor without their consent, right? And he says that's not happening here. No one is legally owning someone, and no one is forcing anyone to work for them and taking the fruits of their labor. But what Harlan argues is that in abolishing slavery, the 13th Amendment essentially restored what he calls universal civil freedom. So it's a phrase that Plessy's attorneys use and said, look, when you get rid of slavery, what happens in a society? Everybody regains their natural freedom, right? It's one of the principles of the American founding, that all people are by nature equal and free, right? And that means that they're free people until they commit some kind of crime and we can put them in jail, but otherwise their natural position in the world is free. So if you remove slavery from them, what happens? They're restored to their natural freedom. So one of the arguments that Plessy's attorney made was, look, what's a characteristic of a free person? They can move where they want to. Freedom of movement, or what he calls freedom of locomotion, which is funny because it's a train.
Big
But
pun.
freedom of locomotion, they can move. And we're experiencing this now with the question of where people can go in this pandemic situation and what they can do. Freedom of movement is one of the fundamental characteristics of being a free human being, which means, as Justice Harlan says, if you're a free person, you can sit where you want and you can sit with whom you want, but the law does not allow that. So if there were a black man and a white man who were friends who wanted to sit together in a train car and ride to wherever they were going, they couldn't do that under this law. So they did not have the freedom to move where they wanted to in the train, and they did not have the freedom to associate with each other in that train. So what Harlan says is, you're misunderstanding what the situation here is. In getting rid of legal slavery, we've restored people to their full natural freedom that they possess in society as a human being. And that's one of those freedoms, to associate and to move about. And I think why he's so passionate on this point is he's saying to Brown, you're not understanding what actually happened when the 13th Amendment was passed. You think the law got changed. And he says, no, something bigger than that happened. It's not just the law was changed, the whole condition of a people was changed, from enslaved to fully free, as free as they naturally would have been before they were ever involved in a society or before they were ever enslaved.
That's a great way to put it. Yeah.
And I think Brown is saying, wait, I don't see any of that. That's not in the law.
Yeah. Wouldn't he say Harlan's reading too much into the law in that case, right?
Yeah, absolutely. But Harlan wants to say this is what really was at stake in the Civil War and in getting rid of slavery.
Yeah, that's fascinating. So, then Harlan, this is a fascinating way that you put it. The 13th Amendment restored a people to its full natural freedom. And Harlan puts a lot of emphasis on the protection of what he calls equal civil rights. Is the reason, therefore, for that equal civil rights are the enjoyment of equal civil rights are vitally necessary to enjoy this full and equal freedom in a natural sense that you're describing?
I think it's really twofold. So I think that when Harlan and Plessy's attorney made this argument, he said the 13th Amendment is about restoring the freedom of human beings. So as a human being living in a society, you have the freedom to go where you wish and sit with whom you wish. The second, he says, the 14th Amendment comes in when he's saying, what does it mean to be a free citizen? Right? Because the 14th Amendment, when you look at it, is all about citizenship. It's the very first line of the first section of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, right? So the question is, what does it mean to be a citizen? A free citizen. The 13th Amendment is out, what does it mean to be a free human being? And so they have an argument over what the 13th Amendment did, but then they shift from that argument to the 14th Amendment and say, well, all right, then let's argue about what it means under the Constitution to be a free citizen.
I see. That's fascinating. So Brown, of course, talk in his treatment of the 14th Amendment argument, I think essentially is saying, I agree in the principle of equal protection of the laws under the 14th Amendment. But in this particular case, the example of separate but equal railway cars, that is not a violation of equal protection of the laws. That's a law that is founded in what he wants to make a distinction between legal distinctions, which he seems to support or disagree. Say legal distinctions are not constitutional, but social distinctions are. So his out seems to be to make a distinction between legal discrimination and social discrimination. Legal discrimination not acceptable, but social discrimination is beyond sort of the scope of the Constitution. So in separating whites and blacks into separate cars, there's social discrimination, but what legal right, I think, is his argument. Tell me what legal constitutional right or civil right is being violated by requiring whites to sit in whites only cars and blacks to sit in black only cars.
I think that's right. And that's an interesting way to put it, right? So he's sort of throwing the question back on to Plessy and saying, so what there in the 14th Amendment really was violated. And it's interesting because Plessy argued and his attorney argued, look, this law cannot be considered just in isolation. It's got to be considered as part of all of what's going on in Louisiana and all of what's going on post Reconstruction to roll back the civil rights and the gains that African Americans and freed slaves have made, right? So they say, look at it in this broader context. And what they say is this law is completely arbitrary. As you said, the 1/8 rule, the 1-drop rule, how do you enforce it? It's completely arbitrary. In other words, there's no good reason to do this, which makes us suspect that it's part of this larger animus, this larger hatred of white people against black people, right? And what's interesting there is Brown has to deal with that argument.
Yeah.
So what he wants to say is, and we're learning this now in the COVID situation, every state government has what's called police powers, right? They have the power, that's what the constitutional experts call them, police powers. They have the power to make laws for public safety, public health, public welfare, and public morals. That's the typical definition of it. So like speed limit laws are an example of police powers. They regulate your freedom for the sake of public safety, public health, public welfare, and public morals. When Louisiana's law is challenged, like, why'd you make this law? It's just part of this larger attack on African Americans. Louisiana says, no, it's not. We're doing this to ensure peace and good order in society.
Right.
And in fact, that's what Brown says in the opinion, right? He says, look, they can't just make crazy distinctions and say black people must walk 3 streets over only between 4 and 8 at night, or something crazy and weird like that. He says, what they're saying is they can't sit in the same rail car as whites, and whites can't sit in the same rail car as blacks, right? It's equal in that way, for the sake of preserving social peace.
Yeah. No, I'm looking at this.
A valid exercise of the police power to just keep order and peace in society. That's what, and Brown agrees with that.
Yeah. I'm looking at this one paragraph from Brown where he writes, legislation is powerless to eradicate racial instincts or to abolish distinctions based upon physical differences, and the attempt to do so can only result in accentuating the difficulties of the present situation. If the civil and political rights of both races be equal, one cannot be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. So in that one paragraph, he's sort of trying to kill several birds with one stone. He's pointing out, he's implying the police power, right? This is the most peaceful, if you will, solution to underlying racial and social tensions. So he's, again, referring to the police power, the idea that the state has police powers. Um, um, uh, but I think he's also again pointing out, he's trying to argue that, look, in a way, separate but equal still recognizes equality. What he wants to do is point out or try to downplay the separate aspect of this, and remind us that that even in asserting separate but equal, we're still asserting equality. And in a way, Brown seems to want to argue that um, that, the importance of this doctrine is that it does assert equality, legal equality.
Because if it didn't, it would clearly run contrary to the 14th Amendment, which says that no state shall deny to any person within its jurisdiction the equal protection of the laws, right? That's right there at the end of Section 1 of the 14th Amendment. So states have to give citizens equal protection of the laws. The question is then, well, what does that mean? And Brown, because Harlan says in his dissent, look, please, we know why this law was made.
Yeah, right.
This law was not made to keep white people out of black people's cars.
Right.
This law was meant for the opposite purpose. This law was meant to essentially re-enslave black people or take away their equal citizenship. We know that's why it was made. But, and therefore, any law that has racial animus at the bottom of it, at the base motivation, he says, must be contrary to these amendments. That's not equal citizenship if law is based on hatred of one group of citizens. But of course, look, that might be true, but Brown's argument is, but the Constitution doesn't see that. The Constitution doesn't know that. The Constitution simply asks, but is the law equal, right? And is it a reasonable exercise of government's power to keep peace? Right. Which is why I think we get to Harlan's second and most famous argument. Right? Because on the one hand, he wants to say, if this is a law motivated by racial discrimination and animus, it's unconstitutional. Brown's response is, but it's not. It's motivated by a desire to keep the peace.
Right.
In this case, that means the law needs to separate whites and blacks so there isn't trouble on rail cars. And I think that's what gets Harlan's most famous argument, where he says, look, part of being a citizen is not just being treated equally in having a rail car, physically equally, but it's being treated by the law without regard to your race.
Yeah.
And I think that's what occasions he wants to say, look, even if you can claim this is a so-called legitimate exercise of government power to keep the peace, the first question is, does government even have the power to see your race?
That's a great point.
And that's when he has that very famous paragraph where he says, it doesn't. Our Constitution is colorblind. Because I think it's an answer to that argument. Well, this is a reasonable police power regulation. Sometimes government needs to see the race of its citizens so that it can keep them apart and keep peace and good order. And his response is, government doesn't even have the power under this new amendment to see the race of its citizens. Like colorblind, sometimes we miss the metaphor, right?
Yeah.
It means being blind means you literally don't have the ability to see something.
Right.
So government does not have the power to see the race of its citizens. So any law that takes into account or sees the race of citizens would be unconstitutional, according to him.
Yeah. As Harlan writes, in view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no, that's a key line right there. The law regards man as man, human being as human being. And in that language, this reminds me of the point you were making earlier, Jeff, where you're talking about restoring the effect of the 13th Amendment was to restore a people to full natural freedom. That line, the law regards man as man, it's a subtle, it's just 5 or 6 words, but it's a very powerful reminder of one of the fundamental principles upon which the American founding was based, and that is human beings equally have certain rights, or they're endowed by their creator, as the Declaration says, with certain unalienable rights, simply by virtue of the fact that they are a human being. and not taking into consideration race or caste or something like that, right? So this is I think, a very powerful, important um, nod back to the original idea of the Declaration of Independence, that human beings have rights as human beings. That is, they are natural in that sense, right?
And so I think that's a really important point, right? Because the question is, why is the Constitution colorblind? Because government doesn't have the power to see your race at all. It just literally is blind. Why doesn't it have the power to see your race? Because as he says there, because it's supposed to see you as a human being.
Yeah.
And what is it about you as a human being that it's supposed to see? It's supposed to see your natural freedom.
Yeah.
It's
Perfect.
supposed to see what the founders called your natural rights, right? Your right to life, liberty, property, pursuit of happiness, the things you mentioned from the Declaration of Independence. That's what it's supposed to see. And the important principle there is none of those things depend on or are connected to your race.
Yeah.
If government's job is to protect your freedom and your freedom is not connected to your race, then in order for government to do its job, it doesn't need to see your race.
Perfect.
So he says it's just a logical argument in his mind. And I would say this goes back to that phrase, there's no caste here. This goes back a little bit to his background and upbringing, right? He was a Whig, as you said, and the Whigs were very famously in favor of allowing common people to rise, as Abraham Lincoln was a Whig originally, right? And what can we do to help common people to rise and improve their situation? And he was very much a Whig along those lines. So the idea of a caste, a superior group of people over another, was to a guy from the backwoods of Kentucky a lot less likable than perhaps someone from a more upper class family in the North.
That's a great
There
point.
might be a little bit of background there, at least in the use of the phrases. But the argument, though, goes all the way back, I think, as you said, to the Declaration of Independence and the founding.
Yeah.
If government's job is to protect your rights and your freedom, and your freedom and rights don't depend on your race or aren't connected to it, then how can government have the power to see your race? It just has to regard you as a human being.
Oh, that's great. I hadn't thought about it that way. So caste, a caste is a kind of permanently fixed position in society, right? In which there is no upward or downward, but no upward mobility, so to speak, or opportunity to rise above the situation that you're born into. So,
and what we know about free people is they rise and they fall.
yeah, as a result of their freedom. That's fantastic.
Mm-hmm.
So what a powerful argument. I can see again why Harlan gained the reputation he did, at least from this particular dissent. And again, the extent to which it is rooted in these larger ideas, the principles of the Declaration of Independence in a way, and the American founding. Boy, what am I trying to put this? If I take a step back, in light of a lot of the things you've been saying, Jeff, Brown's interpretation of the constitutionality of this law is informed more by an emphasis on the importance of maintaining order. Maybe I'm overdoing this a little bit, but when you interpret the Constitution and you ask the question, are segregationist laws, so long as they're equal, are they constitutional? He's thinking more in terms of maintaining kind of order and stability in society, from that view of the police power that you were mentioning earlier. Harlan seems to be, and maybe I'm overdoing this, reminding us that interpretation of the Constitution should always be done in light of an interpretation of the Declaration or even more fundamental principles. I'm not sure if I'm putting this the right way.
Yeah, I think that's right. Look at Brown is looking at it from the point of view of of law and what government does, or government's connection to law, and law brings order. So let's interpret the Constitution in light of what the law says and its job of keeping order. And what Harlan wants to say is let's interpret the Constitution and law in light of its deeper purpose, which is to protect the freedom of human beings.
Perfect.
That's right. But what's interesting to me is I'm just thinking about Brown versus Board of Education now, right? That what's interesting to me, and I think it's one of the myths of Brown, And I would even challenge maybe the title of this entire seminar, right? The seminar is, as Ben said, the beginning and end of segregation. I think one of the myths of Brown is that the Brown versus Board of Education is that it ended segregation in the United States.
Yes.
It didn't actually do that. and the struggle against segregation goes on for years and years and years after 1954, as we know, right? I think another myth of Brown versus Board of Education is that it overrules Plessy versus Ferguson, and it does so by adopting Justice Harlan's dissent. But that's not actually true.
Neither of those things is true, right?
They're myths.
Yeah.
I've heard them repeated a lot by a lot of people, but they're not true, actually.
It doesn't overturn Plessy. Plessy remains standing law, right? Even after Brown.
Yeah. Well, Brown, I think if we can look at the Brown decision, right, there's that passage there where when it mentions Plessy versus Ferguson, what Justice Warren says, Chief Justice Warren, and there's some great background stories again on the Brown versus Board of Education case, both how the case got there, the NAACP's legal strategy of getting the case there. All of that is really fascinating and amazing. And the recent movie that came out about Thurgood Marshall and his time as a lawyer, the NAACP, I would highly recommend to students and teachers. It's just a wonderful sort of what was it like to really be on the ground arguing for civil rights in the pre-civil rights era, we can call it that, you know, the difficulties that he faced personally. But that the argument by Chief Justice Warren, when he looks at Plessy versus Ferguson, what they say is, well, the understanding of psychology that was there is overruled. But it doesn't say anything else about what is overruled, right? Because one of the arguments in Plessy versus Ferguson is, well, you're trying to make, and Justice Harlan and the attorneys for Plessy said, you're trying to make, this is an attempt to stigmatize Black people and make them feel like slaves again. And Justice Brown's response in Plessy was, if Black people feel inferior because of segregation, that's their fault, not the fault of the law.
Yeah.
Which is, of course, a remarkable statement given the context of the world they lived in. Like that just, it can't be true. It's not factually true, but that's what he said. So the question of feeling inferior based on segregation becomes really important in the Brown v. Board of Education case, really important. Right. It's immediately just dismissed by Justice Brown and Plessy, and it's not the argument that Justice Harlan bases his dissent on. So what's really interesting to me is both the arguments of the majority and the dissent in Plessy, neither one of those is the argument that Chief Justice Warren uses in Brown versus Board of Education.
He's going to base the decision on segregated schools on an entirely different question, right? Essentially, so he's not really going to tackle the 13th Amendment. He's not going to revisit the 13th and 14th Amendment arguments of Brown and Harlan. He's not going to make an argument upon higher principles or more fundamental principles the way Harlan did. You might think, by the way, that he could make a kind of technical argument by pointing out that these schools, the separate schools for white children and Black children, violate the principle of separate but equal because they're not actually equal. And he kind of starts to go down that road and say, look, there's a lot of evidence to suggest that the schools for Black children are greatly inferior to schools for white children. But if I read this correctly, Jeff, he even dismisses that because there are sort of too many variables or factors involved in assessing the extent to which these schools truly are equal. And so he wants to move beyond that even and ground this decision on the psychological effect of forcing Black children into schools, which again he says are clearly inferior in terms of buildings and resources and things like that.
Right. So
it's a psychological argument, essentially.
Yeah, it is. That's right. What's really interesting is, and he has to go to that argument eventually. I think because a little bit of history here, and I think some of the students and teachers would know this. Before 1954, the NAACP has been making a lot. They've been chipping away at the doctrine of separate but equal, case by case by case by case. And how they've been doing it is to not attacking separate, but attacking equal. They've been saying, look at these educational facilities. They're not actually equal. They're not equal in their buildings. They're not equal in their classrooms. They're not equal in their textbooks. And they started out their litigation, their lawsuits, by attacking the physical inequality of the schools. Right. They started by focusing on higher education. They didn't start out in K through 12. They started out in law schools. And there was a very deliberate reason for that. They thought judges will understand and be sympathetic to conditions in law schools. So right. They'll get it. They won't understand the plight of poor rural African-American only schools in South Carolina or something. They won't understand that world, but they will understand the world of law schools. So they started chipping away by attacking legal segregation in law schools and showing that they're not actually equal in their physical qualities. And then, of course, the response of a lot of states was, well, we'll make them equal in their their qualities, right? So some states even said, well, we'll just close down our law schools and send law school students to somewhere else. I mean, this is how deeply entrenched segregation was. But then law schools started saying, well, states started saying, we need a law school in our state. So let's make them physically equal, the white law school and the black law school. But then the NAACP started arguing, but it can't just be physically equal. It has to be equal in all the intangibles. Right. The quality of the professors, the quality of the resources and networks available, because being a lawyer means, having a lot of networks with people. The reputation of the place matters a lot. All those things. And they started winning on those issues. So by the time we get to 1954, the separate but equal is wobbling. Yeah. Because it turns out that almost nothing can be actually equal in physical characteristics and intangible characteristics. It's really hard to make them exactly equal. So it's wobbling. It's been undermined and chipped away, but the final blow has not been landed. And that's really what Brown v. Board does. It just lands that final blow against the idea, as he says there, separate but equal is unequal per se, which means just as it is. You can't have it be separate and equal. And his reason is exactly what you say, right? Because, and the argument, your emphasis on walking through the argument is really important here, because what Warren's argument here is, he says, what the 14th Amendment does is establish the principle of equal citizenship. That's the basic fundamental principle underlying the 14th Amendment, which I think Justice Harlan and Justice Brown back at Plessy would have agreed with. But then he says, but what does equal citizenship mean in 1954, in modern times, right? So he wants to interpret the Constitution according to modern times and modern ideas. And he says, in modern times, it means that every citizen has an equal educational opportunity. Because citizenship today depends so much on the education you receive. And then he says, and what effect on education does segregation have? And that's where he argues it harms, because it's psychologically harmful, it actually harms the ability of Black children to learn. So they don't actually get the equal educational opportunity they need in order to be equal citizens.
Yeah, that's right.
And that's where he says, and that's why he has that famous footnote where he talks about the studies that show the inferiority complex that is ingrained in African-American children because of legalized segregation. So it's really the crippling psychological effect that segregation has, which means you don't get the education you need, which means you don't become an equal citizen. Yeah. He puts those pieces together to say, and we got to interpret the Constitution according to modern ideas and modern necessities, which is equally educated citizens. Yeah. So he doesn't adopt the idea that the Constitution is colorblind. He never says those words. They could have easily just quoted Justice Harlan and said, he was right back in the day. That's the principle, but don't, which is really interesting to me. They make this very, I don't want to say convoluted, but complex argument that in the end rests on a psychological premise, which is racially segregated schools create inferiority in students that doesn't allow them to learn, which is and has become over time actually really interestingly disputed. There's been a movement, including among there was a movement in Detroit, Michigan, for example, a largely African American community. People in the community said, we think that all black, all male schools will help psychologically the learning of young people in our communities. And if they help psychologically, under Brown v. Board, can't we establish those?
Yeah, you would think, according to the principle that Warren bases his opinion.
Exactly. So it really raised some. That was, that was 30 or 40 years later when that movement started. But that argument, there's even a high school in Columbus, Ohio called Afrocentric High School, deliberately created on those grounds.
Fascinating. I didn't know that.
Yeah. So, but it's interesting. They didn't adopt Justice Harlan's colorblind constitution argument, but then they also said, but separate and equal can never be equal because of the psychology involved.
Right. So I'm just looking in the text of the decision here to point to where Warren says some of the things that you're really nicely articulating, Jeff. He says, for example, education, compulsory school attendance laws, and the great expenditures for education demonstrate our recognition of the importance of education to our democratic society. It is the very foundation of good citizenship, he says, right? And today it is the principal instrument in awakening the child to cultural values, preparing him for later professional training, and in helping him to adjust normally to his environment. And he goes on a little bit further down in the opinion to say, the effect of separation on educational opportunities, where it was well stated by the finding in the Kansas case by a court, which nevertheless felt compelled to rule against the Negro plaintiffs. His point is segregation of white and colored children in public schools has a detrimental effect upon colored children. The impact is greater when it has the sanction of the law, for the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. And here I think are some really key sentences. A sense of inferiority infects the motivation of a child to learn. Segregation with the sanction of law, therefore, has a tendency to retard the educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially integrated school system. Whatever may have been, and then, in the next sentence or two, he brings it back to your initial point, which is this entire way of thinking about or reasoning through the issue means the arguments of Plessy v. Ferguson are in fact no longer valid, right? So he goes on, he says, whatever may have been the extent of psychological knowledge at the time of Plessy, this finding is amply supported by modern authority. Any language in Plessy v. Ferguson contrary to this finding is rejected. So with one sort of sweep, he says, the arguments of both sides in the Plessy case really are no longer relevant, and must be replaced by this new understanding, which again, it's very complicated, but laid out really nicely.
I think one of the things that, a couple of the myths that we'll sometimes see in textbooks are that Brown versus Board desegregated America, and that it established a clear understanding of the place of race in the law in America. And what's really interesting is because of this reasoning, and I think he did this reasoning, by the way, because look, Earl Warren was a politician. He had been governor of California. When he was renominated to be governor, he was nominated by the Democratic Party, the Republican Party, and the Progressive Party. Everybody liked Earl Warren in California, okay? So he was used to getting groups of people together, and he got a unanimous decision. And he twisted arms and cajoled people in order to make the decision unanimous. There's no doubt about that. He used his best politician skills to get that done because he wanted the court to speak in one voice because he knew how controversial this would be.
Yeah.
But this did not immediately desegregate schools. There have been interesting studies, right, that show, because that's sometimes textbooks will say that. In fact, no, right? If that were true, we wouldn't have had Martin Luther King Jr. and the Civil Rights Movement, which came after this, not before it. Because studies show that at the year after this, only 0.1% of schools that had been racially segregated in 1954 were desegregated in 1955. 0.1%. 99.9% of schools were still segregated. And it took not until by the time you get to 1964, only about 10% of schools that had been legally segregated before were now desegregated. So for 10 years, only 10% of those schools got desegregated. And what happened in 1964 is the federal government passed a law that said, if you want federal money for your school, you have to desegregate.
Right.
And all of a sudden, everybody started desegregating.
Right.
Because they wanted federal money. But it was really interestingly Congress, not the Supreme Court there, that actually had the effect of starting desegregation. And the other thing is that this did not really clarify the place of law, of race in American law under the Constitution, right? So can you use race? We still have the affirmative action controversy, right? Because, well, can you use race in a way that doesn't stigmatize African Americans? This opinion would seem to suggest maybe you can, and if you do, maybe that's constitutional. But then other people have argued, no, the opinion says that people have to be treated the same, regardless of their race. Yeah. And so Brown has been hailed as a great Supreme Court decision, and it has a really important, obviously, place in our history, but it goes different directions and interpreted in different ways. And so it didn't settle things in the way that sometimes people want to say that it did.
Yeah, or maybe it did settle some things, but it also opened up, in a way, I don't want to say a new can of worms, but new approaches and interpretations to emerging.
And a lot of things, by the way, students should know this, and I'm sure they do. A lot of things were still segregated besides schools after 1954. Golf courses, swimming pools, all kinds of things were still segregated. And because of Brown, they had to continue to have lawsuits claiming that this, segregated swimming pool has the psychological effect of creating inferiority, just like segregated education did. And there was a series of many, many, many lawsuits that had to build on Brown, because Brown did not just say all of it is unconstitutional.
Yeah, that's a great point. Well, I think we're out of time. In fact, we're over time. But Jeff, I just want to say thanks for having this conversation. I always learn a great deal from my conversations with you. So, and this is certainly a case of that happening. So
thank you very much. That was a lot of fun.
That was very much fun.
I hope I learned a bit. It's good, always good to talk with you, Chris, and great to be with the students as well.
Thanks, everybody.
Thanks to both the professors, and thanks to all of you for coming. This webinar will be archived on the teachingamericanhistory.org YouTube channel within the next few days if you'd like to rewatch it or share it with someone. And the first 3 webinars in this series are already available on YouTube. If you enjoyed the webinar today, please look into Ashbrook Academies, our summer programs for high school students. We typically hold those academies on our campus in Ashland, Ohio, but we recently made the decision to conduct this summer's academies on an online format. But regardless of the format, the academies include a lot of discussions like you heard here today, using primary sources to explore the past. If you're interested in that, please visit ashbrookacademy.org for more info. I also want to mention that if you're considering a major in history or political science in college, Ashland University is a particularly good place for you to look at. If you want more information about our undergraduate program, the Ashbrook Scholar Program, please visit ashbrookscholar.org. If you're a senior and still undecided about where you'll be attending this fall, we do still have slots left for 2020. Our next webinar will take place a week from today on Thursday, April 23rd, and our topic will be MLK, Malcolm X, and the future of race relations in America. So probably a lot of the same topics that we discussed here today will be continued over into that one. Dr. Burkett will be joining us once again for that, and we'll be joined by Dr. Cara Rogers. So we look forward to seeing you all back then. Thanks a lot, everybody.